Do you have a loved one in a nursing home or facing that possibility? If so, this is a trying time. You don't know the rules or what you'll do if you run out of money. You're powerless against the system and you don't know what your legal rights are. Hello, my name is Steve Daugherty and I'm a Montana elder law attorney. At Montana Elder Law, our firm helps Montana families navigate the nursing home process. In addition to the emotional and financial stress of your loved one's care, families must also endure the stress of being powerless to the system. And though most nursing homes are filled with compassionate people, you must understand their financial duty is to the corporation's bottom line, not yours. Also, they are not lawyers, so they cannot give legal advice. Many Americans are under the false impression that Medicare pays for long-term care. It does not. Medicaid, on the other hand, does pay for long-term care, but qualifying can be very tricky. Medicaid's first objective is to screen out those who do not qualify, so oftentimes the first response is a flat denial. It is your duty to prove to Medicaid that you qualify, and all presumptions are against you. Medicaid typically uses two tools for denials. Number one, deny for being over-resourced, and number two, deny based on prior gifts made by the applicant. However, like most laws, there are exceptions to the rules based on public policy. Fundamentally, Medicaid is a program based on public policy, such as we want to prevent a sick spouse from impoverishing a well spouse. We want to take care of our disabled population as well as our wartime vets, and the policy encouraging family members to take care of their elders, and many more. So it's important to know these exceptions to the rules regarding your countable assets and the 5-year look-back period for gifts made by the applicant. So how does one qualify for Medicaid? The applicant cannot have more than $2,000 of countable assets. Note that I did not say total assets, did I? Well, it begs the question, what are countable assets and which assets are not countable? Countable assets include all liquid assets and almost any asset that can be sold and converted to cash. However, it is possible to convert some countable assets to non-countable assets if you understand the guidelines. Non-countable assets are specific exceptions to the countable assets rule and are based on public policies including, but not limited to, the primary residence, one vehicle, prepaid burial plans, and certain Medicaid-compliant contracts and investments, and several others. The problem is that the vast majority of the public is unaware of these exceptions and needlessly liquidates these exempted assets in order to pay the nursing home bill. If married, the well spouse is allowed to keep a certain amount of countable assets. This is called the Community Spouse Resource Allowance. The amount of assets the well spouse may keep is calculated by dividing all of the couple's countable assets by 2 as of the snapshot date. The snapshot date is the first time the applicant entered the facility for more than 30 days, or the date of the Medicaid application, or the date a screening determination was created. There is a minimum threshold of $25,000 and a maximum of $126,000. Therefore, a couple with $25,000 of countable assets at the snapshot date will not have to spend these down, while a couple with $252,000 will have to spend down $126,000 before the applicant is eligible for Medicaid. Finally, any gift you made in the last 5 years will be counted just the same as if it were in your savings account. This is called the 5-year look-back period and is designed to prevent Medicaid fraud. But remember, there are public policy exceptions. A gift includes any asset you sold for less than fair market value. A gift also includes adding someone to your bank account, and even Christmas gifts. When Medicaid identifies a non-compliant gift, they will assess a penalty period before you may qualify. The penalty period is the amount of the gift divided by $242 per day. As an example, if you put your $200,000 house in your child's name, then that results in a penalty period of over 2 years. However, it is possible to cure these gifting penalties and remove that penalty period when done within the rules. As you can see, qualifying for Medicaid can be very complicated, and one wrong step may result in a denial costing tens of thousands of dollars in nursing home expenses. Most people are unaware of the laws designed to prevent a family from going broke while ensuring their loved ones receive all of the care they deserve. When you learn how the laws allow for families to convert countable assets to non-countable assets, you regain the power over your loved one's cost of care. To learn these laws, seek the advice of a licensed elder law attorney to guide you through the process. At Montana Elder Law, we perform a full case analysis for clients where we analyze your family's unique situation and compare cost of care versus your income and assets. We then present our findings with a plan to convert countable assets to non-countable assets, cure potential gifting penalties, and provide a roadmap to becoming Medicaid eligible. We look forward to helping your family save assets and secure the proper care your loved one deserves. Thank you.